My name is Daniel White, Your Honor. And you, ma'am? My name is Maria Gomez, Your Honor. All right, Mr. White. What is your claim today, Your Honor? I'm here because Ms. Gomez, she owes me $500 for the security deposit on my apartment that she never paid. A security deposit. Is that right? And why do you believe she owes you this money? I'm a landlord, Your Honor. I rented a room to Ms. Gomez a few months ago. We had a written agreement. It said that she was supposed to pay a $500 security deposit and the first month's rent. On her move-in day, she paid the rent, but she never paid the deposit. She said she would get it to me the next week. That was 3 months ago. Miss Gomez, what do you have to say about this, Your Honor? I told him I didn't have the money. I was waiting for my paycheck. And then my car broke down, and I had to use the money for that. I told him I would pay him as soon as I could. I tried. I really tried. But he's not an understanding person. He just wants his money. He doesn't care about my problems. Mr. White, do you have a written agreement? Yes, Your Honor. I do. It's right here. It's signed by both of us. It says, tenant agrees to pay a $500 security deposit on move-in. It's right there. She signed it. She agreed to it. Miss Gomez, is that your signature on this document? Yes, Your Honor. It is. But I told him I couldn't pay it right away. He said, don't worry about it. Just move in. You can pay me next week. He said it was okay. I trusted him. He said it was okay. This is a case of a verbal agreement versus a written agreement. The law. It is very clear. A written agreement. It trumps a verbal one. You, Ms. Gomez, you signed a contract. A contract is a legal document. It is the promise. And the promise was that you would pay a $500 security deposit. You did not. The fact that he may have said, don't worry about it, is irrelevant. That doesn't change the terms of the contract. A handshake or a verbal promise. It does not negate a written agreement. You took a risk. You moved into an apartment without paying the full amount, and you expected that he would just forget about it. That is a naive assumption. He is a landlord, and a landlord has a right to collect what is owed to them. You owed him a security deposit, and you never paid it. Your argument that you had other problems, your car, your paycheck, that is a problem for you to solve. It is not a legal defense. Your financial problems, they do not absolve you of your financial obligation. You had a written agreement. You signed it. You broke the promise. I find in favor of the plaintiff. Mr. White. Miss Gomez, you owe Mr. White $500. Case closed. My name is Robert Wilson, Your Honor. And you, ma'am? My name is Janet Adams, Your Honor. All right, Mr. Wilson. What is your claim today, Your Honor? I'm here because Ms. Adams, she owes me $1,000 from my dog. My dog's medical bills. She was dog sitting for me, and she let my dog get her. Your dog. Is that right? And what happened to the dog? He broke his leg, Your Honor. A clean break. I had to take him to the vet, the surgery, the x-rays, the medication. It cost me $1,000. I have the receipts right here. She was supposed to be watching him. She was supposed to be taking care of him. Miss Adams, what do you have to say about this? Your Honor, I did not hurt his dog. I love dogs. I would never hurt a dog. I was watching him. I was playing with him. He was running round the backyard. He's a puppy. He's a little clumsy. He just fell. He just fell wrong. It was an accident. It was not my fault. Mr. Wilson, did you have a written contract with Miss Adams? No, Your Honor. I did not. We were friends. I trusted her. She said she was a good dog sitter. I thought she would take care of my dog. Miss Adams, what is your response to this? I'm a good dog sitter, Your Honor. I've been doing it for years. Nothing like this has ever happened before. I was watching him. I was right there. He just tripped. It was an accident. And I am not responsible for an accident. This is a case of bailment. Mr. Wilson, you gave your dog, your property, to Miss Adams. She was the bailee. And as the bailee, she had a duty of care, a duty to take reasonable care of your property. And she failed in that duty. The dog, he was in her care, under her supervision, and while in her care, he was hurt. Your argument, Miss Adams, that it was an accident, holds no water. A dog sitter, a professional dog sitter, is supposed to prevent accidents. A dog sitter is supposed to ensure that the dog is safe. You failed to do so. A dog sitter is responsible for the dog's well-being, and you were negligent. The fact that you were friends, the fact that you didn't have a contract, that is irrelevant. When you take on the responsibility of someone's property, you are liable. You are liable for any damage or any injury that occurs while the property is in your care. I find in favor of the plaintiff. Mr. Wilson, Miss Adams, you owe Mr. Wilson $1,000. Case closed.